4-1, State of Wisconsin versus Heather Honeycutt. Ms. Honeycutt pled guilty to count 1, burglary of a building or a dwelling, she pled guilty to theft, movable property greater than $100,000, a felony F or an F felony. Is the victim or one or more going to be making a statement?
Yes, yeah.
My wife and I are local business professionals and taxpayers of the county. We give back to our community by donating time and money to local organizations, including Lakeland Family Resource, Sacred Heart Church, the Spooner School District, Scott and Spooner Fire Department, snowmobile clubs, and the city and county law enforcement. My mother, Mary, is a widowed, retired special education teacher who taught in the Frederick School District. I have never met Heather Honeycutt, and she has never had my permission to be on my property. My only knowledge of her is that her and her boyfriend are friends with my former contractor. In March of 2024, I went into my pole barn and the door was unlocked, which I thought was strange. After going inside, I look over and a lot of my property has been moved around. And in the corner of my barn, I saw that my mother and my family's safe has been dug up and stolen. After my family passed away, I had major issues with the bank getting access to my safety deposit boxes. So I just decided to buy a safe, put all the estate items into it, and bury it where no one knew where it was. Inside of the safe was my 9mm handgun, my grandmother's multi-generational diamond ring, my great-grandfather's watch, and gold and silver coins, and multiple other family property that is irreplaceable. The only people who knew where that safe was located was my wife, my mother, and my father-in-law who helped bury it. The thieves were able to get into my pole barn without any forced entry. And the only person that had a key prior other than my family was my former contractor who was friends with Heather. The thieves or Heather somehow knew right where that safe was located in the back corner of my pole barn, buried underneath a foot of dirt where I had heavy machinery and deer stands on top of it. It was located where no one would ever know where it was, and it hadn't been touched in years. There's no possible way any one person could have lifted that safe by themselves, and I know Heather had help in stealing this safe. And I would gladly agree to no sentence if she would just tell me who the main people are responsible. My mother is a widowed elder woman, along with myself, my wife, and my 2 young children, age 5 and 2. Knowing that Heather and other thieves had came onto our property and stolen a firearm, along with my family's legacy, makes me extremely anxious, afraid, and we do not feel safe in our own home. I've had to spend significant amount of money to install additional security measures so our family can still continue to live at this residence, but in fear. Since the initial theft, we have been targeted again and another shed broken into with no other neighbors broken into, and the person on the footage has a very high resemblance to Heather's boyfriend. Law enforcement is very aware of the other parties involved, and these people have no respect for law-abiding citizens. The dollar amount of this theft is also extremely high, but the monetary amount doesn't really matter to me as much as my family heirlooms, as I would give anything to have my grandmother's multi-generational diamond ring back, because I was going to give it to my son to give to his future wife someday. The amount of this theft, as you stated, qualifies as a Class F felony. If she would just tell us who the main people are responsible for this theft is, I would gladly agree to time served. But with the amount of theft, no cooperation on naming the others involved, no recovery of the firearm, and never being able to get my family legacy items back, I think the plea is light in terms of sentencing if she is going to take full responsibility for this. I thank you for your time.
Thank you.
This is a joint agreement for 18 months initial confinement, 42 months extended supervision and costs. And she's the one who happened to leave behind evidence. A cigarette butt at the crime scene where she told law enforcement she'd never been, the presence of her phone in the same area where she said she'd never been to, suspicious messages between her and the only other man who's not in Mr. Fry's family who knew where the safe was buried. And then some of the stolen property started to be recovered to people that can be connected through her 7 degrees to Kevin Bacon style through phone logs, Dakota Barf to Justin Pfaff to Heather Honeycutt. Law enforcement obviously has strong suspicions about certain people connected to Honeycutt who have substantially more criminal history than her, as being the main people involved in planning and executing the heist, as well as the contractor who knew where it was buried. We've talked about that at length when we talked about previously at the plea hearing and why it's in the public interest for this a plea agreement to be. The reason there's only enough evidence to convict her versus them is likely because of their greater experience and skill at avoiding incriminating themselves. Basic things like not talking to the police, not keeping their cell phones on their persons when they're committing crimes, not leaving behind physical evidence. This is the primary reason for the joint agreement. This is clearly not one of the main people primarily responsible for planning, thinking up, and executing this heist. If it was, she would have posted bond long ago, as her bond that she's being held on cash for is a fraction of what this property was worth. Instead, the stolen merchandise has been, stolen property has been showing up in the hands of other people who are either more responsible or are friends of people more responsible. That being said, given the nature of the burglary, literally a safe heist of possibly the largest amount of valued property stolen in the history of our county, probation would unduly depreciate the seriousness of the offense.
While she has been in custody awaiting this day, there's been a limited amount of services that she could have received in the jail, but the ones that were available, she took full advantage of. And I think you can see that from the letters that were included in the sentencing memorandum. Thou shalt not steal. It goes back to the 10 Commandments. That is how ancient this offense is. And the legislature has seen fit to classify this offense as a misdemeanor. What makes this such a serious offense, what makes it a Class F felony, is the value of what was taken. Not necessarily that any aggravating factor in terms of how the theft was carried out or what was done with the property or to who. It simply comes down to dollars. So I ask you to keep that piece of it in perspective. No one was physically harmed. No one was threatened with harm. There was no violence alleged by anybody. No threat of violence alleged by anybody. Is that she is not a danger to the public. Heather's mother and her daughter, Candace, wrote to you, Judge, and I'm just as miffed as they are that Heather wanted to plead. This case to me is one that should have been tried. True character is how you act when the chips are down. The chips have never been this down for Heather. We've done our best to tell you her life story in the sentencing memorandum, and there have been some downs. There have been some downs, but the chips have never been this down, Judge. And so I want to draw your attention to page 14 of the sentencing memo, who, as far as I can tell, was a perfect stranger to Heather. And I want to quote things that Crystal had to say about Heather when she met her in the jail. It was probably Crystal's low point in her life. And what she said about Heather was, she reminded me that I still had value and purpose. When I felt I was falling apart, she was there for me. But what I hope you see from the sentencing memorandum is that what Heather has done with her time waiting for this day is to try to build people up. I ask you to adopt the joint recommendation.
I want to start by saying that I want to take accountability for the wrong choices I've made that have brought me here before you today. To the victims, I truly and deeply apologize to you and your family. Also to the community and to my family. I know my actions have affected them as well. Before being incarcerated, I was headed down a destructive path. I knew I needed a change. I sat and prayed, asked for a way to help me change this path I was going down. I never expected it to be going to jail, nor did I want it to be that kind of circumstance, but it was. I needed a wake-up call, and I definitely got one. This last year has been one of the hardest and most life-changing lessons I've had to go through. While being in here, I lost everything. My home, my family was divided. I was abandoned by someone I love. My oldest daughter had to take responsibility of taking care of my youngest daughter while taking care of her own child. I stood in front of the mirror and I realized I had to face myself. I had to change myself because this is not who I was or who I ever wanted to become. Remembering what my family taught me is that the greatest strength you can find to lead you on the right path is that anything is possible through Jesus Christ who strengthens you. This last year has truly changed who I am and who I want to be. It's also opened my heart to what God has called me to do. While being in here, I've attended Bible studies and groups that I'm very thankful for. They helped in growing my faith and my mental and emotional strength. When I said that God opened my heart to what He's called me to do, I say this because also while I've been in here, I've met a lot of different women going through their own battles as well. And I realized that God gave me a gift of encouraging others through my own testimony. Also, while being in here, COs have pulled me aside to talk to other females to help. All right. When I am able to get back into the community, I want to be able to help others. I've already connected with a church and groups. I would like to go to college to become a counselor. I believe that my testimony of what I've been through can help others. As it says in Ezekiel 36:26, and I will give you a new heart and I will put a new spirit in you. I will take out your stony, stubborn heart and give you a tender, responsive heart. God cleansed me this past year so that today I can say thank you and look at this year as a discipline that turned into a blessing. Thank you, Your Honor.
How do I say this? You have been through a lot in your life. As much trauma as one can possibly have in your childhood. But your life wasn't easy. I know you credit Justin for being a person to help you move away from your heroin addiction, but he still wasn't good for you.
No.
He still continued to bring you down the wrong path, and forefront became methamphetamine and other crimes, other things. You have to change your habits. You have to change the people you associate with, and you have to change yourself. I really want to see you as a counselor, Ms. Honeycutt. You are a very encouraging person to others in despair. You're able to listen to them, provide them guidance, while you are yourself facing the same thing or worse. It's a lot of money. Over $100,000, perhaps more, maybe up to 200,000. I don't know. I haven't had the restitution hearing yet. But it's not about that dollar amount. The victim and his family have lost so much more than money. You can always make more money, earn more money, do more things to get money. You can never have money replace security, sanctity, heirlooms, a ring that was passed down from generation to generation. I can't say with any amount of anything that the second burglary or attempted burglary at the victim's property is in any way related to this. You're in custody. You were not involved in any of that. Sometimes it's been shown in our cases over and over again that once you're victimized, sometimes they get hit again by others or by the same people. And that continues to destroy the victim's sanctity. I mean, if you can't bury a safe in the ground, far under the ground, and put heavy machinery over it and other heavy things to protect it, other than a safe deposit box, and some people don't trust banks, where are you going to put it? Because if people find it and they are able to get it there, they're able to get it anywhere. And you were a part of that, Miss Honeycutt. Whatever role you played, you were a part of that, a part of destroying the victim's sanctity. And both parties, both counsel are correct in the fact that I must first consider probation. I fully believe, Ms. Honeycutt, you were a minor role in this burglary, in this theft. But you played a role. You had other actions and conduct that you could have done to prevent this. You could have called the police. You could have let the victim know that something may happen and he could move the safe. And I'm going to tell you, I heard from the victim here. I don't believe he wants to destroy you. I don't believe he wants to see you go to prison for the rest of your life or for the maximum penalty. I believe he fully wants you to rebuild yourself, change your course, and be a better person and help the community, be a counselor, help others, other information. Because the unknown is what worries us the most. Or something like that is the quote. Because you were not the sole perpetrator. You were not the sole criminal involved in this incident. There were others. 1, 2, 3. How many? No one knows, but you and maybe your counsel. You are not falling on the sword, Ms. Honeycutt. You do not have to take that upon your shoulders, Ms. Honeycutt. I don't even believe this was your idea, Ms. Honeycutt. You do not need to protect others who have failed you, who have seen you sitting in that chair time and time again, knowing that you could go to prison, who did not.
This right here might be the biggest turning point of the entire hearing. Notice what the judge is doing. He's not saying Heather is innocent, and he's not removing responsibility. What he's doing is separating participation from leadership. That distinction matters in sentencing. The judge keeps coming back to one idea. If there were bigger players involved, why should one person carry the entire weight while others stay invisible? But there's another layer here that makes this emotional. The victim already said something powerful earlier. They weren't asking for maximum punishment. They wanted answers and the return of family history. That changes the atmosphere of the courtroom completely. Now the pressure shifts from punishment to accountability. So here's the question. If someone plays only a smaller role in a major crime but refuses to reveal the people behind it, should that reduce their sentence or make it worse? Tell us what you think.
Care one bit about you taking the blame wholeheartedly. This is a case where I understand the objective of the agreement. You are a small party, a little potato in the big crock pot of pot roast. And I have to look at treatment options and the ability to avail yourself of the programs in prison, because I can't guarantee you're going to do that when you are released, and I can't order that as an extended supervision condition. So what I'm going to do is I'm sentencing you to 2 years of initial confinement. I'm giving you a step up. It seems like a harsher sentence with 6 more months to have to sit, but you may not have to sit that if you engage in the program. I want to see you engage in that program, Ms. Honeycutt. You are 40 years old. If you don't take control right now, it will take control of you. Time after time after time. So 2 years of initial confinement, followed by 3.5 years of extended supervision, $518 in fines and fees. We need to schedule a restitution hearing. I am also ordering that you cooperate with law enforcement regarding potential of others involved and cooperate by providing information if you have it or know of it as it relates to the heirlooms, the firearm, the ring, the other heirloom items that were mentioned. Can't order you to disclose, but I can order you to cooperate. And I'm going to tell you, Ms. Honeycutt, you have to look out for you, number one. You are number one. Your kids are number two.
In addition to that, the condition on cooperating. Can we revisit that? I've never seen or heard of that. I don't even know if it's a
We've done
lawful.
it multiple times here.
All right, so can I ask some questions about it then?
Yes.
It's a significant condition because if she doesn't cooperate, then she could get revoked, right? So I want to make sure that I understand what that can,
I can't force her to say anything.
then what is, then so Heather understands and we make it clear, what does it mean?
Cooperate means if they say, hey, Miss Honeycutt, let's have a talk. There's a talk.
Her obligation under this condition is to, if law enforcement asks to meet with her, she has to take the meeting. She has to be there in the meeting, but she can plead the fifth and not
That's her
provide information.
constitutional right. That's why I specifically said I am ordering her to cooperate with law enforcement concerning if they want to talk about those things. I can't force her to disclose. Don't know it's perplexing because this has been ordered multiple times and asked for by the state multiple times in multiple cases, at least up north.
I'm sure it has. I've never encountered it before. And I think it's a fair question that she understands because the consequences of not
Again,
cooperating.
My job isn't to inform her of her rights. That's your job.
Yeah, I understand. But
My job is to look at the victims and make a condition and you tell her what is within her constitutional rights.
unfortunately, I don't run the Department of Corrections. I see them make wacky decisions and interpretations of court conditions all the time. And so this one concerns me. We've made a record of it. You've said that she can exercise her constitutional rights. And if this ever becomes an issue in the future, it'll be in the JOC, it sounds like.
Never had to do that before. An attorney has never questioned that because they usually counsel their client and say, you have the right to your Fifth Amendment right to remain silent.
Well, I guess I'm different.
And that's where this case ends, but not where the questions end. Heather Hunyut ultimately receives 2 years of initial confinement, extended supervision afterward, financial penalties, and one unusual condition: cooperate with law enforcement if contacted while still retaining constitutional protections. What makes this case stand out isn't just the dollar amount, it's the emotional damage. The court repeatedly emphasized that stolen money can sometimes be replaced, but family heirlooms, security, trust, and peace inside your own home are much harder to recover. At the same time, the judge acknowledged something unusual. He believed Heather may not have been the mastermind and pushed her to stop protecting people who may never protect her back. This became less about one burglary and more about choices, influence, accountability, and whether change is real or just words spoken at sentencing. If you found this courtroom case as intense as we did, drop your opinion below. Was the sentence fair? Hit like, share this video, and subscribe for more courtroom breakdowns and real legal analysis.